The evening that we have all been waiting for is finally here. I would request all of you to please take your seats. Good evening, everyone. I, Rajiv Bharadwaj, on behalf of the Eastern Book Company, feel deeply honored to welcome you all to the release of the SCC Pre 69 volumes. I would first like to welcome the dignitaries on the dais. We are honored to have with us the Honorable Chief Justice of India, Justice NV Ramana, as the chief guest for the evening. Justice Ramana, not many know, began his career as a journalist and also fought for civil liberties during emergency. After taking up advocacy as a career, Justice Ramana went on to serve as the Chief Justice of the Delhi High Court before being elevated to the Supreme Court. In his 8 years at the Supreme Court, Justice Ramana has been a part of more than 650 benches and has authored around 170 judgments. From being a young boy from a small village in Andhra Pradesh to becoming the Chief Justice of India, Justice Ramana's story is truly an inspiration. It is an honor to have you here with us, sir. I would request Mr. Vijay Malik, Managing Director, EBC, to felicitate Justice Ramana. Next, I would like to welcome the special guests of honor for the evening. It is a privilege to have with us this evening Honorable Justice BV Nagarathna, Judge, Supreme Court of India. Justice Nagarathna began her career as an advocate practicing in various courts of Bangalore, after which she was appointed as the additional judge of Karnataka High Court. She was confirmed as a permanent judge in 2010, and after serving at Karnataka High Court for 13 years, Justice Nagarathna was elevated to the Supreme Court last year, giving us Indians a hope for something that is long overdue. We cannot wait for Justice Nagarathna to write history by becoming the first woman Chief Justice of India. We are extremely honored to have you here with us, ma'am. I would request Mr. Sumeet Malik, Executive Director, EBC, to felicitate Justice Nagarathna. Next, I would like to welcome Senior Advocate Mr. Arvind P.Datar. Mr. Datar, in his over 40 years of practice, has appeared before the High Courts as well as the Supreme Court in several landmark cases, such as the Aadhaar Right to Privacy case, the Vodafone Income Tax case, the National Tax Tribunal case, the SEBI Sahara case, the NJAC Appointment of Judges case, to name a few. Mr. Datar is also a member of the Editorial Board of SCC. Known for his humility, Mr. Datar is an inspiration for all the first-generation lawyers who aspire to make it big in the legal profession. We are delighted to have you here with us, sir. I would request Mr. Raghunandan Malik, Director, EBC, to felicitate Mr. Datar. We also have with us on dais Mr. Sumeet Malik, the Chief Editor of the Supreme Court Cases, and Mr. Sumeet Malik, the Associate Editor of Supreme Court Cases, the two persons who lead the team responsible for bringing the accurately head-noted and perfectly edited SCC volumes to you. The launch of SCC Pre 69 volumes is the result of their vision and leadership. I would request Madhav and Myra to felicitate Suren sir and Sudeep sir. It is also gratifying to have with us in audience Honorable Sitting Judges of the Supreme Court of India, Justice Vikram Nath and Justice JK Maheshwari. We also have with us Justice Sikri, former Judge Supreme Court of India, and Justice KK Lahoti, former Acting Chief Justice of Madhya Pradesh High Court. A warm welcome to them and to all our guests. मैं अकेला ही चला था जानिबे मंजिल मगर लोग साथ आते गए और कारवा बनता गया. These words by Majru Sultanpuri most accurately describe the journey of SCC, which started in the year 1969 with one man's vision and has now enviably become the most reliable law report in the country, with the efforts of hundreds of people who over the years joined Mr. Sumeet Malik in his vision. Every single judgment published by SCC has 27 copy editing inputs in order to make it as readable and user-friendly as possible. And continuing with this tradition, SCC will now also cover the period for which it was not in existence. I am sure that our audience is eager to know more about SCC Pre-69. So without taking more time, I would like to invite Mr. Sumeet Malik to say a few words.
My Lord, Chief Justice Ramana, my Lord Mr. Nagarathna, Mr. Datar, Justices of the Supreme Court, former Judges of Supreme Court, Judges of the High Court, Senior Advocates, ladies and gentlemen. It is my honor I wish to welcome Justice Kaul. Good evening, sir. It is my honor and privilege to welcome all of you on this momentous occasion for the EBC group. It has been a cherished dream for us because we always felt SCC as it is now told half the story. The one before, from 50 to 68, was the most momentous years of the Supreme Court, when the seminal ideas were laid down in many of the judgments over which later judgments developed. And it is a great honor that the Chief Justice of India will be releasing the first 5 years of the proposed Pre-69 volumes. I am particularly excited today because it is a culmination of the efforts of 3 generations. The founders of the EBC group, Malik Chunilal Dhal, then aged 26, and my father, Prakashlal Malik, just 18, laid the foundation of the EBC group in 1942. they had the vision to create an institution in which legal publishing would be related to India by Indian authors, Indian material, and that would be more relevant to the Indian legal system. During the course of his working life of over 60 years, Shri Chunilal Malik encouraged, initiated as many as 200 authors. And he also gave to us as a legacy what he himself practiced, that the way to do business is in a mantra of honest, sincere hard work. The family over the years has witnessed that the success story based on this principle is so true that we are all very proud to follow it. The principle was carried forward in practice by Shri Prakash Lal Malik, my father, when he propounded that a legal publication has to be authentic, accurate, and reliable. He was a perfectionist himself, and he built an infrastructure that stood true to the values he held. And so, for the statutory law, he resorted only to the original source, namely the India Code and the gazettes. And we saw as children, post-dinner, he would be poring over gazettes of India, noting down on his card system all the acts, rules, notifications. Later on, all that came to be that he brought industrial law, a book that is known all over the country and is now in its 25th edition. It was known for its accuracy and reliability. So were his other publications like Criminal Handbook and many other books. It is the same principle that we carried to SCC in 1969, and we resolved that we will only publish when we have the original certified copy of the judgment, and that is what we have held true till date. So the major effort when we thought of the pre-69 was firstly to have a complete list of all the cases of this period. We searched through every possible source, all the law journals, and we discovered that there were many judgments that were not published in any of the law journals. The second step then was to secure the certified copies of all the judgments, even if they had been published in any of the law journals. We still wanted to have the original resource. And I must say that in this search for the cases, we found unreported judgments not reported anywhere. And one of the cases was a 6-bench judgment in Dhanraj Giri Raja on corporate law. It's published in 1950, SCC before you on page 69. And it will be interesting to see that this unknown decision of 6-bench, how it affects the later judgments. And in the process now, and this is what I feel very proud of now, that we have a priceless collection of the original copies of the original judgments with corrections in longhand by the judges of that period. We retain all such copies for the future as a backup and to support what we publish. In all these years, there has been only one instance when late senior advocate Mr. Ashok Desai wanted one word to be confirmed. And I sent him the photocopy, and he was very, very happy. We had this question before us early about non-reportable judgments. The history revealed to us that this was the criteria used or devised for the ILRs of the high courts, because they had a limited number of pages, and therefore the judges had to write whether it's a reportable or a non-reportable judgment. The same tradition carried and came to the Supreme Court and was adopted for the official Supreme Court reports, that they will publish only the reportable judgments. But my research and my study, when I was preparing the complete digest of the Supreme Court from 1970 over the years, revealed that there were many judgments which were not reported in SCR but had been reported later by AIR, ITR and other journals, and were being followed in the Supreme Court itself. Therefore, to me, this distinction actually had no meaning. More than that, I referred and read Article 141, which says that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Therefore, as long as I could find a law declared, meaning if I could formulate a head note and a principle from any decision, to me it meant that the mandate of 141 will prevail and such judgment has to be reported. And interestingly, whether a case is reportable, non-reportable, or the unreported, which we are going to publish, once they are published, the distinction no longer survives. All of them are good precedents and binding law. By publishing the unreported judgments, we hope to add a lot more cases to the body of cases already as precedents of the Supreme Court. The second thing which I read in the words law declared was a mandate and a duty for law editors that they must examine closely and extract all the points of law from a judgment. And that is what we have been doing and following in SCC. And the same is being done for the pre-69. So there is going to be a lot more case law that will be added to the body of case law already available. The second part of 141 says binding on all courts. And therefore, the question was, how do we bring that in the sense that I have head noted, I have extracted the law, formulated the principle, but how does it come to the notice of the people concerned, the lawyers? How would they know that there is a ruling on this point? And therefore, it became very imperative and obvious that there has to be an index system that is rational, detailed, and one that we follow consistently, so that once people are used to it, they know where to go and find the law. One thing, of course, is very obvious and which was followed by the AIR is to put everything statute-wise. To the extent that I, when I began my work, found that there was no heading for administrative law. Everything relating to that was put in the Article 226. Similarly, there was nothing on interpretation of statute. It was all put under CPC preamble. Well, they were following a system, that was their choice. But I had to do both. I said there are subjects like that which do not admit to a statutory approach because there is no statute, and therefore the topic approach became very important. Also, in our federal structure, when there are laws of all the states in subject like rent control, the principles would be applicable all over the country. Take something like bona fide requirement. If it decided under one state statute, it will prevail in other states as well. And therefore, in subjects like rent control, sale tax, and other such tenancy laws, we adopted the topic approach. What always occurred to me, and as I met more and more people, was that everybody actually carries an index system in their head. Everybody has its own. And in the old days, I came to know and I saw that senior advocates or others, they would have a register in which they would make notings of their favorite rulings. So I had to reach to every possible way in which a person would be seeking a ruling, and therefore the need for multiple cross-references. This index system that has been built over the years has been evolving. Today it runs to around 1800 pages, and with time we have combined topics, we have re-evaluated. The number of headings go down to 7 levels, 6 to 7 levels. What the other consideration to my mind was, after all, what is it that I am aiming at or we are aiming at through this system? A lawyer, always pressed for time, would like to know the few rulings in his favor as well as those against him. So we have to arrive at that handful of rulings on a particular topic or issue before him. And as I believe, it is imperative, if the true legal research has to happen, that one has to exhaust the law, know exactly what is in favor and what is against. And that is where this index system comes in handy. We are lucky, and this happened to the benefit of everyone now, that we have a software of SCC Online which permits even more easier research. You give anything, any word that comes to your mind, place, name, judge, year, anything, and it will find the rulings for you. And then the search within search method narrows down the search to the point where you want to go. What else I found most exciting in publishing the pre-69 cases was to see what happened later on, how that case treatment of the later cases. And we found many cases that have been overruled. A very famous instance is of A.K. Gopalan that was overruled in Maneka Gandhi. And therefore, we have in our volumes, in the headnote itself, made a note with extracts of how those cases have been overruled, with a caution. The caution being, it is never the whole case that is overruled. It is certain parts, the rulings, that are overruled. And therefore, in the same case of A.K. Gopalan, you would find this note of being overruled in 3 places, but the rest of the law is still good law. So these fine distinctions have to be made. In our SCC Online, we have created a button up in the 3rd column, near where you have the printer and all that, called reference button. You press that and you get the list of cases where that case has been cited or discussed in later Supreme Court and High Court decisions. So only the very selected comments are there in the headnotes. For the rest, we commend to everyone that they should go to SCC Online and look it up for themselves. What are the later cases of how they have been treated because the more, everybody knows that, the more a case is followed, it is a better authority, and the more it is distinguished, it is less and limited. Another important feature in these pre-69 is that we have reported the cases chronologically. We were able to do it, and now every case is one after another, and all cases of 1 year are in one volume or more volumes relating to that year. So therefore, it is easier and convenient, or that's even obvious, to under the precedential value of any decision. What happened later, what happened before, and date-wise and all that. It is also important that in evaluating the precedent, we go by the bench strength. And I know that sometimes it may be a bit cumbersome to count the number of judges. So in the margin, we have done the work, homework, and there it is in bold letters, what is the strength of the bench. In the footnotes, with the references of the case where it has come from, the High Court decision, we, on the suggestion of Justice Nagarathna, added whether it has been affirmed or reversed. Thank you very much, ma'am, for that suggestion. So all in all, the unique features and quality of SCC has been replicated in the pre-69 volumes. And it is time for me to acknowledge the immense support, guidance I received from the members of our editorial board, who had always spared time for me, gave their suggestions, support, and ideas. And succeeding generations of editorial members have contributed to the growth and success of SCC, and I am indeed grateful to all of them. Some of them are here, including Mr. Datar and Mr. Neeraj Kishan Kaul. And you will see in the 1950 volumes on our request, many, many messages have been received, starting with Justice Venkatachalaya and other former judges of the Supreme Court, sitting judges of the Supreme Court, chief justices, senior advocates, and I'm truly, truly humbled by their appreciation and their encouragement for this venture. But then, as I said in the beginning, it is the efforts of 3 generations in this work, and the foremost, and I'm not saying this out of a formality, it is a reality, that I owe so much to my wife, Deepa. She is an MA in English literature. She could have pursued a career in teaching or research or whatever, but she understood what I was trying to do and took over literally everything about the household and the family, the joint family, the bringing up the children. She and Neelu went around and brought up all the children, and I'm very proud of the fact that all the children have post-graduated from abroad and are now part of the SCC family. To further Article 141, in that it says it will be binding to all courts within the territory of India, meant a great challenge and a task for my brother Vijay Malik and his son Raghunandan, and they had a great team who went to every part of the country and ensured that SCC reached every part, and that means all the judgments of the Supreme Court are available across the country in all district courts and all major chambers in the country. VP Puneet Pavaiya, he's here. Could you still stand up? Yeah. He and my youngest brother Sumeet, way back in the 90s, designed the architecture of SCC Online and have made it good enough to process 2.3 crore pages on the click of a button. Miles to go, Puneet, there's a lot to do. More significantly, Sumeet and his VP Sanjay Kapoor and their team have made SCC Online a household name and have contributed immensely in training more than 11,000 judges at the district court level in how to use SCC Online. It is our belief that if the decisions of the lower courts are in accordance with the law laid down by the Supreme Court, the number of appeals would be far less. Sumeet, assisted by Sumeet and his student ambassadors, has also spread SCC Online to over 200 law schools, and students have started using SCC Online and getting to do legal research in the right way from the very beginning while they are students. And that is the future for this country. Sumeet himself has been engaged in creating a huge database. Today, SCC Online is not confined to the Supreme Court. That is hardly a small percentage now. We have covered all the high courts of the country, the past and current, all the courts of the Commonwealth, US, Canada, and Australia to some extent, Ghana and other things. This huge database, excuse me, covers not only case law, but also other materials down up to the tribunals, also commission reports, articles written by, which appear in many, many journals. In one stroke, you have the panorama of all the material on any issue of law by searching this huge database, which has a few million of documents, and it is very, very wide, and it keeps on growing. Raghunandan is doing great work by making SCC volumes available along with Indian law books over the web with his EBC web store. He's created one more database called EBC Reader relating to statutory law and the commentaries. Abhinandan, not to be left behind, has created e-learning, which is lectures on law for the benefit of students and those who want to upgrade their skills. It also has a module for those appearing for the AOR exams. Karan, the youngest, through his Mercury app, informs in advance if the hearing of your case is coming up. All the dates of different levels are available and are recorded and decimated. The Malik family is fully committed to fulfill the vision of the founders to support the rule of law. Thanks to their blessings, today a board of 8 directors, 4 LLMs, 4 MBAs, and a strength of 400 dedicated staff produce all the product and services, and the new ventures continue to grow and will keep coming. For this moment, I've asked the 4th generation to be present and witness this. Madhav, Myra, Dia, please. I do feel that the future will be taken care by the next generation as well. I sincerely thank all of you for being here and encouraging us in this great moment, and particularly I thank Justice Ramana for blessing this venture and inaugurating it today. Thank you all.
Thank you, Suren sir. Your dedication towards SCC is indeed quite infectious. We are also honored to have with us Justice Sanjay Kishan Kaul and Justice C.T. Ravi Kumar, Judges, Supreme Court of India, and Justice Rajiv Shakdher, Judge, Delhi High Court. Thank you for being here, sirs. Next, I would like to call upon Mr. Arvind P.Datar to say a few words on the occasion.
Honorable the Chief Justice of India, Justice Ramana, Honorable Justice Nagarathna, Justice Vikram Nath, Justice Maheshwari, Justice Sikri, Justice Lahoti, and Justice Shakdher. We have very pleasant memories of appearing before him in the Madras High Court, and all distinguished members of this audience. I join the chorus of congratulations to the entire EBC team for undertaking the publication of all the volumes from 1950 to 1968. With this, the gap will be complete and they'll have the full SCC set from 1950 onwards. I had the occasion of seeing some of these volumes, and what will be particularly useful to practitioners is that they have taken care of pointing out how a particular case has been discussed, referred, not just saying overruled, reversed, etc. For example, in the case of A.K. Gopalan, they have specifically pointed out which part has been overruled in bank nationalization, which has been overruled in Shambhunath Sarkar, which has been distinguished in Maneka Gandhi. So these volumes have been very well prepared, and the editorial notes are really going to be extremely useful to all the practitioners confirmed. The two new volumes, the present set, will now represent the first 2 decades of the Supreme Court, which was indeed a remarkable period where the most important landmark judgments were laid down and which continue to be followed. I remember when I just joined the bar in 1980, just a few days after I joined the bar, a very old senior lawyer saw me working in the library, and he said that just note 2 things. Take the 15 years digest, 1950 to 1965. We had the 15 years digest, then we had the quinquennial digest thereafter. So he said, please take the 15-year digest and please see the important judgments which are mentioned in those digests in Constitution. And if you read from 1950 to 1965, you will know enough of constitutional law that it'll help you in good stead. The second piece of advice he gave me was, All India Reporter had these volumes of Privy Council, published volumes of Privy Councils. And there the index would give them single star, double star, triple star. I don't know if the youngsters know about it. So depending on the importance of the judgment, they would be star marking. So he told me that go to these Privy Council judgments and please read the starred judgments. I took the advice to heart and it proved useful. Now, a Supreme Court is not just the building, but also the judges and the lawyers who make it. And when I read parts of it, you really feel not only the great judges, Mahajan, Patanjali Shastri, Mukherjee, but also the great lawyers like Setalvad, Daftari, M.K. Nambiar all seem to come alive. So when we read these judgments, we are not only going to see the great judgment, but also the great arguments which were made at that point of time. Now, what was particularly fascinating to me was, if you read, for example, Champakam Dorarajan, you will find that in those days, without the internet, the kind of scholarship that has gone into these judgments, because our constitution borrowed from the US, Canada, Australia, Ireland, Japan, and so on. So it was a great amount of research that was done. And at this stage, I will just suggest to the EBC team, if you can, when you prepare a note, you're not only doing editorial notes, but see if on important landmark judgments, if you can go to the High Court judgment and make a comment on it. because I also feel, for example, Gannon Dunkali's case, 58 Supreme Court, the Madras High Court judgment of 54 Madras is outstanding and is worth commenting when you're making the new edition again. Take Anwar Ali Sarkar. This was a judgment from West Bengal, but you must see the 5-judge bench of the Calcutta High Court and Anwar Ali Sarkar, which is equally remarkable. So while we're preparing this, one suggestion is you could perhaps make a comment and see those landmark High Court judgments which can be commented upon. Now, in the short span, I've been given 10 minutes, so I just thought that I will make a mention of some of the important dissents which had been mentioned here and which to me really are the life and spirit of this great Supreme Court. Of course, the first dissent we have all know is the great dissent of Justice Fazal Ali in the AK Gopalan case, where if you now look back, contrary to what the remaining 5 judges said, it was a bench of 6 judges, there were only 6 judges at that time, till Chandrasekhar Iyer joined in September 50. He was the person who dissented, Mahajan dissented partly, but his depth, his vision of constitutional law, and he said that, look, please don't see preventive detention in isolation. Don't take Article 21 separately, 22 separately, 19 separately. These are all a harmonious whole, and unless you see them integrated, you'll not really decide the importance of individual liberty or personal freedom. And his vision proved right, where almost 20 years later, the bank nationalization case said that, look, you must see these articles in the thing. Now, according to me, in my humble opinion, the greatest judgment, not just the greatest dissent, but the greatest judgment of our Supreme Court is the dissent of Vivian Bose in Anwar Ali Sarkar. This judgment was delivered on the 11th of January 1952, exactly 70 years from now. What was that case? 50 dacoits, 50 armed men raided a factory in Jessop, the Jessop factory in Dum Dum. They were caught and convicted under West Bengal Special Ordinance, 1949. Now just imagine the kind of public outcry, and for a man to dissent and say that the conviction should be quashed requires tremendous amount of courage. Mind you, the Calcutta High Court struck it down, but when it came to the Supreme Court, by this time Chandrasekhar Iyer also on the bench, 6 said that reverse the judgment of the Calcutta High Court, but Vivian Bose alone gave what is perhaps the most masterly piece of judicial writing. And I say this with a great sense. I mean, having written some books, I've had the occasion of reading several judgments, but nothing comes anywhere close to this particular judgment. If you take the SCC online of Anwar Ali Sarkar, Vivian Bose's judgment starts at para 81 and ends at para 98. Just 17 paragraphs of 4.5 pages. Justice Bose discusses the importance of not only Article 14, but also the importance of the Constitution, constitutional values in a sovereign republic. For example, I have noted what he says is that after discussing the scope of these provisions, he then asks the question, he uses the word that our Constitution is not a mummified manuscript. It's not a mummified manuscript, and he says that this living Constitution, he asks the question himself, does the classification offend the social conscience of a sovereign democratic republic? So he elevates a challenge to the level of a social constitution. And then, para 98 is the conclusion. And these words I remember again and again and again. He simply says, when the froth and the foam of discussion is cleared away and learned dialectics are placed on one side, we reach at last the human element, which to my mind is the most important of all. And then he says, I'm not worried about 40, 50 men attacking the Jessop factory. But what is the reason you'll distinguish these people from other convicts? What is the reason you'll try them separately from the others? This is not permissible in a sovereign, civilized, democratic republic, and on that basis, he sets aside the conviction. I always believe that apart from the Law Day pledge, I think all of us must read these 17 paragraphs at least once a year, so that we'll know what a great instrument our Constitution is and what a great judge Vivian Bose was. In fact, he also used the word cribbed, cabin, confined, which Justice Bhagwati used in Royapata, was actually used by him in Ram Singh's case in 1952. Now, just 2 more dissents because of lack of time. I think the other important dissent, which I really love, is the dissent of Subba Rao in Khadak Singh's case, where despite the person being of very unsavory character, he says, I'm not going to decide the case depending on the petitioner before me. We are concerned with a much higher value. And then he discusses what's the meaning of surveillance, what's the meaning of liberty, what is the meaning, why a man's home is his castle. And that great statement that if we don't accept this principle, the entire country can become a jail. Now, just one more point, how these people have molded this relief. All of us would have heard this case of Khajur Singh. I always found it very, being in Chennai, Khajur Singh was always very, very interesting. In fact, to tell you one important point, there is a good excise case on whether you can use the definition in one act in another act. And the name of the case is Barfi Devi. So, like Khajur Singh, this is also another case which stuck in my mind. Now, Khajur Singh was concerned with the question whether Article 226 could lie where against the union government. And that time government was in Delhi and the only case was Punjab. The majority said, in Saka Rao, he says, no, you have to go, the High Court has no jurisdiction beyond its territory. If the officer is outside your territory, then it's over. But Subba Rao, in another outstanding judgment, he says, no, this is not the way to interpret it. And if you read the judgment, the judicial craftsmanship is such, he says, where is the union government? The union government is all over India. And to my surprise, he refers to Order 27, Rule 3, read with Section 79 CPC and says, the union government has no address. If you see the CPC in the plaint, the union government has no address. You simply refer to the union government, that's all. We may put North Block, but that is not necessary. So then he says that, look, the reason why every High Court has a jurisdiction is not where the officer is situated, but what is the effect of his order. If his effect of his order is in Tamil Nadu, then the Madras High Court has jurisdiction. Now, these are the great masterly dissents which I noted, and I thought that I'll share it with you. And looking forward to these volumes. They will fill an important gap. And Dr. Malik mentioned that he has also referred to many judgments which have not been covered. This is going to be a virtual treat for all of us. And of course, I can tell him confidently that out of the various legal websites searches we do, SCC Online is perhaps the most user-friendly search of all. Even compared to Lexis or Westlaw or something, this is the most user-friendly. So I think I join all of you in wishing SCC all the very best, and we look forward to your completing the set, and it will help us in our legal research. Thank you so much.
Thank you, Mr. Datar. It is always a pleasure to hear your thoughts. It is also heartening to see Mr. Siddharth Luthra, Senior Advocate and Member, Editorial Board SCC, with us in the audience. A very warm welcome to you, sir. While Mr. KK Venugopal, Dr. Abhishek Singhvi, and Mr. KV Viswanathan couldn't make it to the event today, they have sent us their messages on the occasion. I would request Mr. Sumeet Malik, Associate Editor, SCC, to read them out for us.
As Mr. Venugopal's junior, it is indeed a privilege to, Mr. Venugopal was here. He called me at 2 in the afternoon, and he said that I'm really unwell and I won't be able to make it, but his blessings are here with us, and I'll just read out very quickly what he had to say. So he says that I'm delighted that Eastern Book Company is publishing judgments of the Supreme Court from 1950 to 1968 in volumes of Supreme Court cases. Supreme Court cases provides a golden thread to navigate through the labyrinth of cases in our country since 1969. This year, they release volumes of SCC for the period prior to the establishment of SCC. SCC is widely regarded as the #1 amongst law reports and replaced all other law reports. Legal publishing companies like EBC have played an important role in widening the access to legal information, which is a facet of access to justice. The success of SCC also lies in its online database, which permits a keyword search to pull out a long line of cases on any particular subject or section of a statute. The gist of our times has been a sustained shift towards increased accessibility and improving information, and SCC is to be lauded for being of immense use to the legal community and judiciary. I congratulate EBC and the editorial team of SCC for the innovative initiative taken by them, unquote. I'm also happy to read the message sent by Dr. Singhvi. says, COVID has deprived me of the pleasure of physical presence to greet and felicitate the SCC family on achieving yet another milestone in their successful journey as numero uno in the field of Indian law reporting. SCC is the platinum standard for quality, excellence, and attention to detail, reader-friendliness, and comprehensiveness. In addition, when I was briefed decades ago by SCC at length as a senior counsel in a SCC copyright dispute with a foreign publisher, I was struck at the long list of useful, special, and sui generis publishing features and value additions brought to the table by SCC, small and big, which we tend to take for granted. I have been on the editorial board for decades and seen them not only grow but keep pace in the changing world with rapid technological revolutions and with innovations in every aspect of law reporting. SCC is its own biggest competitor, and if at all the stately volumes on our shelves will ever be partially or fully replaced, it will only be by SCC's own soft versions, online or digital, or by other forms of evolution. Good, prompt, accurate, and reliable reporting contributes fundamentally to the entire superstructure of the legal system because its bedrock is the doctrine of precedent and the underpinning of the latter is good law reporting. Consistency and an elusive virtue is nonetheless the hallmark of certainty and stability which we legitimately expect from the law and reputed law report publishers who are not riddled with errors and blemishes are a vital necessity for the maximum realization of that virtue. It is also good to see that the Malik family, ever growing, has successfully leveraged the talents and qualifications of its second and third generations to maximize SCC bang for the buck approach for all forms of law reporting and law-related publishing, while anchored in the values and solidity of their founding patriarch. This is the way growth should be, evolutionary, not jerky, continuous, not episodic, rooted in the past while reaching out every day to the future. I wish them all the very best, and I'm sure that the best is yet to come, unquote. And last, I read Mr. KV Viswanathan's message. He says, I'm delighted to note that Supreme Court cases is bringing out volumes consisting of law reports for the years 1950 to 68. This will be another feather in the illustrious law journal's cap. It is no exaggeration to say that the quality of advocacy in the Indian bar, and more particularly the Supreme Court bar, has increased manifold due to the sterling contribution of Eastern Book Company and the Supreme Court cases. While the CD-ROM edition of the law reports SCC was launched, there was a visible increase in citation of authorities before courts. It is further improved with the launch of the online edition. In this background, the proposed law reports SCC to 50 to 68 can only be classified as a treasure trove of gems. Makers and editors of the law reports are definitely part of the joint pilgrimage undertaken by the legal fraternity on the endless road to unattainable perfection. To borrow and adapt Lord Gough's famous passage in Spilier Maritime versus Consilex. Congratulations and wishing you all the best, unquote. Thank you so much.
Thank you, Sumeet sir, for reading out the messages for us. Next, I would like to call upon Honorable Justice Nagarathna to grace the occasion with a few words.
Honorable the Chief Justice of India, Sri NV Ramana Garu, Honorable brother and sister judges of the Supreme Court, Justice Sikri, former judge of the Supreme Court, Justice Shakdher, judge of the Delhi High Court, learned Attorney General for India, Sri KK Venugopal, couldn't make it. However, I would address him. Similarly, Dr. Abhishek Singhvi and Sri KV Viswanathan, I wish them well. Sri Arvind P.Datar, learned senior advocate, Sri Surendra Malik, chief editor, Sri Sumeet Malik, Director, Eastern Book Company and Editor, SCC, Sri Sudeep Malik, Associate Editor, SCC, all members of the Malik family and the SCC family, learned senior advocates and members of the Board of Advisors for SCC, members from the editorial teams, learned senior advocates and learned members of the bar, distinguished invitees, who are present here and those who are online, members from the media, if they are here or online, ladies and gentlemen, good evening and namaskar. At the outset, I must thank the entire team of Eastern Book Company, EBC, and SCC for having invited me as a special guest of honor to this event to launch the throwback series of the SCC for the years 1950 to 1954, which are being launched today. I congratulate the entire team of SCC for their endeavors towards conceptualizing and making concerted efforts towards bringing out this series, which relates to a critical period in our nation's history and also of the august institution, that is the Supreme Court of India, in its formative years. SCC is one of the most widely cited law reports in the country today. With a view to develop a reliable source of reference, SCC at present has compiled all judgments rendered by the Supreme Court from the year 1969. During my interaction with Sri Surendra Malik, I inquired as to why 1969 was chosen as the starting year of the series. It's a very odd year. I learned that it was in 1969 that Sri Surendra Malik graduated in law, and hence the significance. Thereafter, he has pursued his mission of curating and making accessible authentic and reliable legal information by bringing out legal commentaries and the Supreme Court cases, the Law Report series, through the Eastern Book Company. Precedent being one of the sources of law, the principal binding nature of a precedent on a judge is an essential feature of the common law system. It conceives that general principles of law are derived from particular facts or instances of a large number of decided cases. This gives rise to the proposition that individual decisions contain in themselves future authority. Article 141 of the Constitution of India, we all know, has cemented the theory of precedent by declaring that the law declared by the Supreme Court shall be binding on all courts within India. The principle upon which rests the authority of judicial decisions as precedents in subsequent litigation is embodied in the maxim, stare decisis e non quieta mover, which means to abide by precedents and to not disturb settled points. However, in the Indian context, the principle of stare decisis is not an inexorable command. In the words of Chief Justice Felix Frankfurter of the American Supreme Court, the doctrine of stare decisis is not, in his words, an imprisonment of reason. According to Justice Aharon Barak, former president of the Supreme Court of Israel, while precedent is not immutable, he says departures from precedent should be the exception, not the rule. He has adopted the philosophy of Justice Douglas of the Supreme Court of the United States of America when he says, and I quote, "A judiciary that discloses what it is doing and why it does it will breed understanding. And confidence based on understanding is more enduring than confidence based on awe," unquote. That when the scales are balanced, we should stick to precedent. The theory of precedent brings in its wake the system of law reporting as its necessary concomitant. In my view, the doctrine of the binding force of precedent can fully emerge in any judicial system only when there is a settled judicial hierarchy coupled with accurate law reporting. Further, it would not be an exaggeration to state the development of law depends as much on what is not reported as on what is reported. I therefore endorse and applaud the decision of the SCC and other similar comprehensive law reporting agencies which report every decision to which the provider has access to a judgment is nonetheless an authority even if it has not been reported. Otherwise, the question of whether such a judgment could or could not be so regarded as a precedent would depend upon the mere whim of the reporter. Law reporting in India, as we all know, started with the establishment of the Supreme Court in Calcutta in the year 1774. in pursuance of the Indian Law Reports Act 1875, an official series of reports known as the Indian Law Reports was started, whereby each High Court has an ILR series for itself. The practice of citing decisions from reports has led to the publication of a large number of private reports. Notably, one of the publications is the All India Reporter Nagpur, which started publication in 1922, but brought out back volumes from 1914. The relevance of the throwback series that is being launched today, more specifically the SCC law reports for the years 1950 to 1954, is to be understood and analyzed in light of the fact that the series will cover decisions rendered in the first decade after India achieved freedom from colonial subjugation. The period between the years 1947 to 1957 is often referred to as the age of issue formation, that is, the period when issues of national priorities were in the formative stage. In 1950, the Constitution came into force and some sort of an institutional apparatus was visualized with commitments to social change, for instance, in the form of fundamental rights and directive principles of state policy. The Constitution was adopted to force the pace of social and economic renaissance in India and as a step towards social change and nation building. Indian constitutional law was in a sense adopted from various other jurisdictions, as has been said by Mr. Datar just now. In keeping with this prospective need for decoupling Indian laws from their colonial roots, Article 13 of the Constitution has paved the way for judicial review of pre-constitutional laws. Various questions arose with regard to the interpretation of Article 13 itself in light of the other fundamental rights, which culminated in a series of judicial pronouncements in the initial years of the Constitution, including A.K. Gopalan versus State of Madras, which was argued by none other than Sri M.K. Nambiar, the illustrious father of learned Attorney General Sri KK Venugopal. Keshavan Madhavan Menon versus the State of Bombay versus F.N. Balsara, Romesh Thapar versus State of Madras, and State of Madras versus Champakam Dorerajan, etc. The judicial foundations for the various doctrines classifying the clashes and contradictions arising in the interpretation of Article 13 in light of the other fundamental rights were laid during the period between 1950 and 1954. Mr. Datar just referred to the great dissents of the earlier ages and referred to the dissent of Justice Vivian Bose in Anwar Ali Sarkar. I may say that that is the dissent which paid the foundation for recalling the earlier order of the 5 judges by the 7 judges in Abdul Rahman Antule. So therefore, the dissents by a very few judges can be ultimately the leading opinions later on, and thus every precedent, I said, is an authority for the future majority or minority opinion. It can be said that the proposed throwback series is highly relevant from an historical and academic perspective. For instance, the sitting of a bench of the Supreme Court in the then state of Hyderabad that was led by Sri M.C. Mahajan, Justice M.C. Mahajan, with ad hoc judges is also noted from the 1950 report. Similarly, as already mentioned by Mr. Malik, a 6-judge bench judgment is also reported, which is very rare indeed. They serve as points of reference from which the evolution of the constitutional and legal philosophy of the apex court may be traced. On the occasion of the release of a throwback series, I remember the role played by the Supreme Court of India to become, in every sense, an institution for realization of fundamental rights. I acknowledge with respect my predecessor judges who adorned the bench of the Supreme Court with distinction, whose jurisprudential labor breathed life into the substantive rights enshrined in the Constitution and paved the way for the progeny of the 2nd and 3rd generation fundamental rights, and who have kept up the flame of democracy burning bright. I am confident and sure that the Supreme Court will continue to demonstrate compassion, innovation, and fairness to ensure that justice is not genuine. I am confident and sure that in future also the common man can continue to look to the apex court in India for vindication of his rights. I take this opportunity to suggest to the SCC team to venture further into the alleys of the judicial history of India by coming out with a law report series on the available decisions of the Federal Court of India. Then you will be fully and rightfully complete. It is exceptionally noteworthy that through the editorial notes supplied in the case reports in the throwback series, SCC has indicated instances where a judgment has been since overruled. Therefore, these cases serve not only as authoritative texts on the particular decision, but act as a source for research on the evolution of the point of law under consideration in the said judgment. It is often said that the task of an editor of law reports is challenging, more so because of the so-called prolixity syndrome of the Indian Supreme Court. While I do not dispute that the fact that brevity, simplicity, lucidity, and clarity are the essentials of a good judgment, what is also expected of a good judgment is that it undertakes a discussion of arguments advanced at the bar. The arguments must be appropriately dealt with in the editorial notes, and emphasis must be placed only on the arguments and reasoning which form the substance of the controversy at hand, not far-fetched, irrelevant, or red herring arguments. This would lend focus to the editorial note. It is a common criticism that the difficulty in identifying the precise ratio is also attributable to a problem at the institutional level of the Supreme Court, owing to the practice of justices giving separate but concurring opinions. It is said that this practice makes it problematic to identify and delimit the ratio. While I certainly do not subscribe to the view that multiple concurring opinions could obscure the ratio and could therefore be damaging to the theory of precedent, I am delighted to note that the SCC has factored in this criticism or concern too, and accordingly modeled its editorial style. I am impressed to see that in the recent editions of the law reports, they have been indicating in a clear one-liner the crux of the difference in reasons of multiple judges authoring separate but concurring opinions. As discussed through my talk, the importance of law reports within a legal system stems from a variety of factors. Prime among such factors is the core principle that the law is for all and should therefore be accessible. That is why the Supreme Court judgments are now being translated into many Indian languages. I once again applaud EBC and SCC team for publication of a well-edited and annotated reports, thereby addressing inter alia the issue of accessibility, whether for the public or for legal professionals. I once again thank Sri Surendra Malik and Sri Sumeet Malik and the entire team of the Malik and the SCC family for inviting me to share a few of my thoughts today. I wish the management of the EBC and SCC the very best as they continue to strive towards building legal information databases using the finest of technological innovations. This is with a view to provide access to comprehensive, accurate, and up-to-date legal information. Last but not the least, I thank each one of you for your kind attention. Thank you and namaskar.
Thank you, Justice Nagarathna. It was indeed a privilege to hear your speech. I would now request Mr. Vijay Malik, Mr. Sumeet Malik, Mr. Sumeet Malik, Mr. Raghunandan Malik, and Mr. Karan Malik to come on the stage. I would now request Honorable Justice Ramana to release the SCC Pre 69 volumes. I would request all the dignitaries on the dais to open the packages in front of them and hold the volume up in their hands. Thank you, everyone. What a great moment to witness. Justice Ramana, if you could please say a few words on the occasion.
Sister Justice Nagarathna, Honorable Judges Sanjay Kishan Kaul, Justice Vikram Nath, Justice Maheshwari, Justice Ravi Kumar, and Justice Shakdher, Justice Sikri, Justice Lahoti, great lawyer and academician and always source of strength in academic matters and administration of justice, Justice Mr P.Datar, Sumeet Malik, Chief Editor, Sumeet Malik, senior advocates, and other distinguished guests, ladies and gentlemen, and media persons. And they have mandated to say a few words. So I don't want to say much about the prepared text, so I will cut short and I will say one or two important issues which I thought that relevant and necessary. I don't want to discuss about any judgments, cases, and all that. One or two issues which I want to say is there any relevance, what is the necessity of the reporting of judgments, law reporting? It's very necessary. The reason is that the people of the country must know what is happening and they must access the issues decided, the law decided, and the cases which is going on, and the accurate, authentic, eagerly waiting time should be reduced, so they must know exactly what is the judgment is. Because now we have 24/7 channels, every minute reporting channels, and before we complete the sentence, we are seeing flash news and breaking news and all that. In the world of this flooded with a lot of information, and there is a need for accurate reporting and authentic reporting. Otherwise, what is happening is people is confused. There's a big problem, sorry to say, majority of the reportings, they doesn't know what is the oral observation, what is the order, what is the judgment, what is the questioning. If you ask one question, they say that, oh, judge has decided this. Very unfortunate. So you know, judicial process, because lawyers and judges know, but the common man doesn't know what is the exact way of proceedings takes place in courts. Suppose a judge asks a question, a negative question, immediately it will be reported, judge said this. This is very unfortunate. So that's the reason why I feel that there is a need to give a accurate and honest reporting and the judgments. Of course, SCC is not no way concerned with this type of day-to-day reporting and all that. But at least ultimately, after the case is decided, the public at large must understand what is the facts of the case, what is the law decided, and how the law applied, ultimately end result. This is the most important thing which everybody wants to know. So that way, a lot of contribution made by the SCC and EBC, and I congratulate them on this occasion. It's not one day effort. 3 generations of the family members, Malik family, has worked hard, and they brought this prestigious organization and participating in the legal, they are part of the legal dispensation system. I congratulate on behalf of the legal fraternity and the everyone from the legal family, to the legal family. And on the occasion of this, I'm requesting Mr. Malik, please you also start one at least web magazine, day-to-day reporting of the Supreme Court proceedings at least. Why I am making this request is, the reason is this. See, because you have a very experienced knowledge people who knows about the process, who knows about law, what is the reason and intention. So at least people will get a good feel and understanding about the process. That is the reason why I am making this request. Please consider it. I know it's a very difficult thing, but we have to consider this request. Second thing is, you know, Supreme Court cases occupies very qualitative law generals, and we know about the head note and editorial. Apart from that, more user-friendly, people like me who doesn't understand much of the technology and all that, it's a very good thing. So we can, in different way, indexing or otherwise by judge name, by case name, by subject name, you can verify the judgment immediately. It helps the legal practitioners as well as the judges also. My clerks always appreciate SCC Online is the single user resource which we can rely upon, and immediately we can get the information necessary. And another issue, which 2 issues which is bothering me is one is the pricing issue. You know that the country background of the lawyers, particularly urban area lawyers, no problem. City lawyers, no problem. Corporate lawyers, no problem. The problem is with the rural lawyers, that is district and taluk lawyers. They had a lot of problem because their income is very minimal. They are not in a position to afford the legal, particularly the legal journals. So please find a solution to provide some sort of access to these rural lawyers, because they are the grassroots level lawyers where they need a lot of legal knowledge, because they are the formative places, and so they require a lot of support. Please consider. I know it is difficult for me to say because it's all matter of economics, money and all that, but somehow you have to find out some solution. If you can, it helps them a lot. Second thing is about the regional language is introducing the important judgments, because SCC reports the constitutional courts, so High Court and Supreme Court. Now why I am saying is, I am propagating, you know, 2-3 agendas of mine in the sense, in the interest of the institution, not personal agendas. One is infrastructure, the other is filling up the vacancies and the access to the justice, and another thing is that the lawyers or the public must know the constitutional provisions and the constitution. It is unfortunate, we are now celebrating 75 years of independence, still we are in only a few selected people in the urban areas or the legal professional people is aware of the constitutional rights, duties and the constitutional principles. If you take into consideration of the European countries or America, wherever you go, they start with even a small school kid to a old man talk about the constitution and the rights and laws. So we need that type of culture. They must know what is the Constitution says, how they are entitled their rights, how to implement their rights, how to know their duties and all that. So in the process, it is necessary for us, particularly the SCC and EBC, try to introduce at least selective judgments, the importance, crux not the entire judgment in the regional languages, so to enable to access in a simple language and with a short head note, 2-3 pages reporting all important cases, so people will have the opportunity of understanding the important judgment of the Supreme Court or the High Courts. This is one more request. These are all little burdensome and involves finances also, I understand. I hope that some government also can give some money, because they are now starting several projects of popularizing the constitution and constitutional schemes. So we can think of this issue also. Second thing is that the other issues are, I want to take a minute about the judgments. Now, I feel that after working 22 years as a judge, that there is a need to think about writing judgments. Writing judgments in the sense not that the way of the criticism now about the judgment is it's very lengthy and it is like a thesis and unable to find out the exact core issue which we are writing. So I request all the fraternity members as well as the lawyers who are contributing, arguing, try to be simple in judgment, concise and precise, short sentences. Like people must feel like reading a story. Ultimately, end of the day, the consumer of the justice or the litigant public or whoever it is, they must know what is the end result. That is more interesting rather than our own imaginations and philosophies. That way I think we can help a lot to the public. Reasoning and conclusion needs to be clear. This is what I believe. And I hope and trust this will happen. And this is all. I don't want to take much of the time. I thank the EBC group as well as the Supreme Court cases organization and Malik family to give me this opportunity. I thank you, all of you, for patiently waiting and hearing me. And I wish all the best, and thank you very much.
Thank you, Justice Ramana. It is an honor to have the SCC Pre 69 volumes released by you. And sir, I would like to seek your attention to one point that regarding your suggestion on daily updates by SCC, the SCC online blog is very responsibly doing daily updates of all the judgments delivered by all the courts across the globe. Yes, that too, sir. So we will seek your indulgence for a few more minutes. It is safe to say that till about a few years ago, Mr. Sumeet Malik had read every single judgment delivered by the Supreme Court of India. He would carefully draft the head notes and personally check every single copy of SCC before it went to press. This assiduous job is now also done by Mr. Sumeet Malik, the Associate Editor of Supreme Court cases. This evening cannot conclude without us hearing a few words from him. Sudeep, sir.
My Lord, the Chief Justice of India, Justice Ramana, Mrs. Justice Nagarathna, Mr. Arvind Datar, Senior Advocate, most honorable judges of the Supreme Court in the audience and of the High Court, and this most august audience. Good evening, and the first thing that I would like to say to you is that on behalf of the Malik family, we are greatly honored and grateful for you to recognize the contribution made by 3 generations now on what began, very interestingly, in the heat of the Quit India movement. This is not just an august moment for us, when the Pre-69 series is launched, but also the 80th anniversary of the EBC group, because it started in 1942. And it is in that heat that I believe my grandfather and his brother, young boys, who saw India emerging as an idea, the greatest dream of all, that they probably envisaged an institution which would contribute to nation building and the rule of law. And that has sustained and inspired us to create what SCC today is, and we are extremely grateful for the kind recognition given by my Lord, the Chief Justice, Mrs. Justice Nagarathna and Mr. Datar, and others in all the wonderful messages which are published in the first volume of 1950, the very first volume of SCC now. Now, having worked on SCC and SCC head notes now for 20 years, it will now be 20 years since I have been working on this. My father has been working on this for more than 50 years. There are just a very few observations that I would like to share, and to conclude this rather quickly, because I'm sure we've taken your time. The first thing that I would really like to emphasize and bring to your attention, and we put in a great deal of labor on this, and we have a team of very dedicated people assisting us as head noters, and they are all over the country, and one of our most senior people is here with us today, all the way from Bhubaneswar, Mr. Suchit Swain. Please give him a hand. I wonder if I should apologize to him for the white hair, because it is probably in doing SCC head notes that we have given him that. But that is the kind of meticulousness that we go into. And the three key things that make SCC stand out, if I may submit, the first is, and this point was made very eloquently by my father, that no judgment which has a declaration of law is left out. And if I may share with you an astonishing fact, that even in these first 8 volumes that you see right before you, there are about 100 judgments which have never been reported before. So I wonder if what Justice Venkatacharya would say, because in his, it is the very first message which is published in the first volume. He says, I wonder if law reporters are worth the trouble that they create. Because once you publish these judgments, suddenly we do not know in some areas of law where the law actually stands. For that, we are going to make a great effort to bring digests and editorial notes to make sure that that position is not disturbed, or at least there is great clarity in what finally results. The other very crucial feature, and this is where a great deal of effort goes in, is what we call exhaustive head noting. Often it is much simpler to identify the key decision in a case. And that appears to have been the practice in the formative years of the court. And we believe that a large number of very critical rulings of law just simply were lost to us because they never entered the head note. It is, I'm sure, that in the minds of the advocates and the judges of the day, these rulings of law were alive, but they did not carry on to us. And here again, I would like to join issue with Mr. Datar. Truly, Anwar Ali Sarkar is probably one of the greatest and most momentous judgments in our law series. And Justice Bose, I would go so far as to say, that opinion is one of the finest examples of judicial prose in 900 years of the common law. I have not read anything as fine as that, whether it be in English law reports or in Indian. So I would really commend all of you to read that opinion. And because the head noting, with all due respect, the head noting was so inadequate in those years that judgment is not head noted either in the SCR or in the AR, so it's lost to us until people like Mr. Datar have made the effort to cull them out, to bring them out. And the one very striking thing that I would just share with you, one example only, there are several and many to share, and that is the doctrine of arbitrariness. Almost all of us have been taught that it was enunciated for the first time in 1974 in E.P. Royappa. Ladies and gentlemen of this august audience and this dais, I only want to read out one sentence each from the opinions of Patanjali Shastri Chief Justice, Mr. Justice Mukherjee, and Mr. Justice Chandrasekhar Iyer in Anwar Ali Sarkar, and I just read them out, and this is what they say. Article 14 secures all persons within the territories of India against arbitrary laws as well as arbitrary application of laws. The principle of equality of civil rights and of equal protection of the laws is only given effect to as a safeguard against arbitrary state action. Ladies and gentlemen, this is 1952 Anwar Ali Sarkar. We did not need to wait for Royappa to tell us that arbitrariness, or rather prevention of arbitrary action, is the heart and soul of Article 14. Mr. Justice Mukherjee goes on to say, purpose of Article 14 is to secure every person against arbitrary discrimination, whether occasioned by the express terms of a statute or by the improper application of a statute, though duly constituted agents. I wonder if he is not laying down the test of manifest arbitrariness right here in 1952. And lastly, Justice Chandrasekhar Iyer, any arbitrary division or ridge will render Article 14 moribund or lifeless if officials exercise their public authority in a discriminatory or arbitrary manner. The same would bring them within the scope of prohibitions of the arbitrary clause. Ladies and gentlemen of this august audience, this has been our endeavor to mine these gold mines of case law and to make sure and ensure that every ruling of law that is contained in these judgments is now brought to you and are indexed as thoroughly as they are in the yearly digests and the complete digest series. The point on which I would like to conclude, again, I would like to join issue with what Mr. Datar said, and he shared the fact that the dissenting opinions truly have what has been called the brooding spirit of the law. And truly, what are we here this evening to venerate? We are grateful from the depths of our heart that you honor us and SCC. But I think we are all here to honor something even higher. And if I may say, one of the finest things that human civilization has created, and that is judge-made law. For judge-made law, unlike parliamentary law, is normally not based on fiat. As Mrs. Nagarathna said, Justice Nagarathna said, and quoting Justice Frankfurter, he said, let us breed understanding and rule through understanding rather than by awe. And that is what judge-made law does magnificently, because ultimately it is the strength of the reasoning that will survive. You may have 8 judge benches like MP Sharma on the issue of privacy, which will fall by the wayside. You may of course have that very famous majority in ADM Jabalpur which changed the course of the dissent changed the course of Indian history. So it is ultimately not the binding strength, it is the persuasiveness, those gentlest of human values, which finally makes judge-made law, I think, what we are here to venerate. And if I may conclude by paraphrasing what Justice Holmes said in a slightly different context, the life of the law of precedent is not binding precedents, because binding precedents are very easily distinguished if judges are not really persuaded, for material facts can vary very simply. So ultimately, a judge must be persuaded of the wisdom of the precedent. So I submit to you that the life of the law of precedent is not binding precedents, but persuasion. Thank you all, and thank you all for being here. And again, we are very deeply honored by your presence here. Thank you.
Thank you, Sudeep sir. That was quite a speech. And this was quite an evening. We wish to offer our heartfelt gratitude to Justice Ramana, Justice Nagarathna, Mr. Datar, for taking time out of their busy schedule to be with us this evening. Mr. Datar has made this special trip from Chennai. We would also like to thank the sitting and former judges of the Supreme Court of India, as well as the High Courts, for gracing the event with their presence. No work of this magnitude can be of one person alone. Our heartfelt thanks to the EBC team, the editors, the proofreaders, the DTP operators, tirelessly working in putting together the SCC Pre 69 volumes. Our production team and Thomson Press, who have ensured such high quality printing and binding. The sales and marketing team, who will truly take the SCC Pre 69 volumes to the people. We would also like to thank Bar and Bench and Live Law for covering the event. Mr. Sumeet Malik, Mr. Raghunandan Malik, Ms. Bhumika Indulia, Ms. Nilufer Bhateja, Mr. Amit Tiwari, and the entire team who, alongside me, put together this event. The Claridges team for helping us in planning and hosting this event. And last but not the least, our audience for joining us on this occasion. We hope everyone who came here on a Wednesday evening feels it was well worth the effort. I would like to thank all of you for being with us on this occasion. With this, I would like to declare the end of this event. I would request all of you to proceed towards the Lutyens Lounge for dinner. Thank you.
To be the one who has to start the channel now.
What channel?
That's it. You weren't listening to him. He said
See, it's already happened.